All right, let's talk about what's happening with Melania Trump and this lawsuit situation, because it's getting pretty interesting. We're into a brand new year, but some things apparently haven't changed, and one of those things is Melania Trump actively avoiding being served legal papers. So here's the backstory. Journalist Michael Wolff is involved in a lawsuit in New York State, and he's basically trying to get ahead of Melania Trump, who's demanding a staggering $1 billion in defamation damages from him. Why? Because Wolff reported on what he claims he heard from Jeffrey Epstein about Melania Trump. Obviously, she's not happy about any of this, but instead of just accepting the legal documents and dealing with it head-on, she's been playing hide-and-seek with the process servers who are trying to deliver these papers to her. It's gotten to the point where they ended up serving the doorman at one of her New York residences, which creates a whole set of problems for her legal strategy. I mean, think about it. If you're trying to argue that you don't live somewhere, or that you shouldn't be sued in a particular location, having process servers tracking you down at that exact location kind of undermines your whole argument, doesn't it? Now, Melania's legal team is pushing hard to get this case moved to Florida. Their argument is straightforward. The case was filed in New York, but she lives in Florida, so the case should be in Florida. Simple, right? Well, not exactly, because here's where it gets complicated. Does Melania Trump actually live in Florida, or does she live in New York? This is going to become a major question as the case moves into the discovery phase, and honestly, it's a fascinating issue that the courts are going to have to dig into. Let's talk about the lawyers involved here, because the legal team Melania has assembled is pretty telling. First, you've got Alejandro Brito, who practices down in Coral Gables, Florida. This guy has become Donald Trump's go-to attorney for defamation cases, essentially the lawyer of last resort when it comes to these types of lawsuits. Then they brought in DLA Piper, which is a major corporate law firm that handles all of Donald Trump's Truth Social corporate matters. And on top of that, they've got some securities litigation specialist representing Melania in this case. It's an interesting mix of legal talent, and they've had to file a letter with Judge Mary Kay Viscochil, who notably is a Trump appointee in the Southern District of New York. But here's the thing, some of this legal strategy might actually backfire on them. In their letter to the court, they identify their client as the First Lady of the United States of America, Melania Trump. Now, they had to submit this letter because of how federal court works, especially in New York. You can't just file a motion whenever you want. You have to ask the judge for permission first through what's called a letter request. That's why we're seeing this letter show up on the court docket. What they're asking for is permission to file a motion to dismiss, and they're leading with what they presumably think is their strongest argument, improper service. They're claiming Melania didn't properly receive the legal papers. But let's be real here. The reason she didn't get served properly is because she's been actively avoiding service ever since the case was filed back in October. She's been moving around between Mar-a-Lago, the White House, and Trump Tower, basically staying one step ahead of the process servers. Look, anyone who knows New York understands that Melania Trump spends the majority of her time at Trump Tower on 5th Avenue, right near 57th Street, directly across from Bergdorf Goodman, that famous department store. This is where she does her spa appointments, has her lunches with friends, goes shopping, and spends time with her son Barron, who's attending NYU down on 5th Avenue. Everyone knows this. Sure, she makes appearances at Mar-a-Lago when there are events or parties she needs to attend, but does that really make Florida her primary residence? These are exactly the kinds of questions a judge is going to need to get answered. And here's what that means practically. The lawyers representing Wolff are going to demand what's called jurisdictional discovery. This means Melania is going to have to sit down under oath and answer detailed questions about where she actually lives, who she lives with, how much time she spends with Donald Trump, and where she spends her days. They're not necessarily going to ask which bedroom she sleeps in, but she's going to be sitting in that chair for quite a while, answering uncomfortable questions about her life and residency. So their first major argument to the judge is that she wasn't properly served with the complaint. But listen, this is federal court we're talking about. Everyone needs to understand how serious this is. It's extremely difficult to successfully dodge service in federal court. There are forms and procedures specifically designed to deal with people who try to avoid being served. You can shift the burden onto the person who's avoiding service, and if they refuse to accept it, they can get hit with fees and costs for making the process difficult. Federal judges really don't appreciate people playing games with service, and even a judge appointed by Trump isn't going to look favorably on someone who's clearly dodging process servers. Frankly, this seems like a losing argument. There are multiple ways under federal rules to achieve service: constructive service, substitute service, or they can send her a form that basically says if she doesn't accept service within the next 30 to 60 days, she's going to be responsible for all the costs associated with tracking her down. There are plenty of tools available to flush out someone who's evading service, which is exactly what it looks like Melania is doing. Then there's their second argument that the court doesn't have jurisdiction over Melania at all. Based on the case law, this argument seems pretty weak too. They're claiming that she's essentially a stranger to New York, and therefore can only be sued there for things that specifically arise from actions she took in New York. Let me break down how jurisdiction works here, because it's actually pretty important to understand. When we're talking about personal jurisdiction, there are two main types: general jurisdiction and specific jurisdiction. General jurisdiction means you're so connected to a particular state that you can be sued there for basically anything. This is typically where you actually live, your legal domicile. You can't really complain about being sued where you live for any matter. Then there's specific jurisdiction, which applies when you don't live in that state, or you claim you don't, but you committed some wrongful act or breached a contract in that state. In this case, the argument is that Melania's lawyer, Alejandro Brito, sent a demand letter to Michael Wolff in New York demanding $1 billion for defamation. The letter listed a bunch of statements that were published in the Daily Beast and other publications about Melania's relationship with Epstein, her relationship with Donald Trump, and the dynamics between all three of them. She didn't like these publications, obviously. So what did Wolff do? He ran to court and filed a lawsuit in New York State Court, which is actually a pretty good place to be if you're a plaintiff. His lawsuit argues that Melania is trying to chill his First Amendment right to free speech, and that her threatened lawsuit amounts to what's called a SLAPP case. That stands for Strategic Litigation Against Public Participation, which basically means filing or threatening to file a lawsuit just to silence someone, in this case by threatening him with a $1 billion lawsuit. His lawsuit also asks the court to declare that none of the statements Melania claims are defamatory actually meet the legal definition of defamation. When you're accused of defamation, you have the right to have a court determine whether the statements in question are actually defamatory or not. Wolff is just doing it proactively, getting ahead of her threatened lawsuit. Melania obviously doesn't like this approach. Her legal team is arguing that sending a demand letter into New York isn't sufficient to give the federal court jurisdiction over her. And finally, they're claiming that Wolff's declaratory judgment action should fail because it's improper. They're saying these statements happened in the past and you can't get a court to make declarations about past events. Honestly, I don't really understand that argument at all. With all due respect to the attorneys who signed this letter, Karen Shechman and Alejandro Brito, they're not exactly known as leading experts in First Amendment law. Looking at Karen Shechman's professional background, she primarily practices securities litigation. Her most recent published article was about cannabis and securities litigation, which is nowhere near this area of law. But they probably think they've got a friendly judge in Viskachil who was appointed by Trump and has ruled favorably in matters tangentially related to him in the past, so we'll definitely need to watch this closely. For those who don't practice in New York, it's worth noting that the Southern District of New York doesn't have many Trump appointees, but Judge Viskachil happens to be one of them. So what happens next? The judge will hold what's called a pre-motion conference, which is typically a conference call. During this call, if you're on Melania Trump's side, you'll get to make your arguments about the motion to dismiss, the lack of personal jurisdiction, and the service issues. The judge will listen to the opposition's arguments and then say something like, "All right, file your full motion with complete briefing under federal law, and I'll review it." Now, this is actually a pretty strange motion and letter brief when you think about it. They're saying on one hand that there was no proper service on Melania, that only the doorman got served at Trump Tower, and that's insufficient service. But at the same time, they're filing this motion as if she did get served, which almost acts as a waiver of the service argument. It's kind of contradictory. It's also odd because the judge hasn't even determined yet whether the case properly belongs in federal court at all. When you file a lawsuit in state court, if you can make a good faith argument that you live in a completely different state than the other party, we call that complete diversity of citizenship. When that exists, the case can be removed to federal court under certain circumstances, depending on how much money is at stake. And there's definitely enough money at stake here for federal court jurisdiction. You do this through filing a notice of removal. The other side can then challenge that notice of removal and any affidavit filed in support of it, and they can get limited jurisdictional discovery to find out where the person really lives. This is probably exactly what Melania doesn't want to open herself up to, but she's already done it by removing the case to federal court. And then there's their final fallback position laid out in this letter, which is going to serve as the blueprint for all their future motion practice. Even if everything else fails, they want this case transferred from New York federal court to federal court in Florida. I've handled cases where we've moved cases from state court to federal court and then from one federal court to a different federal court in another state, and then benefited from whatever case law was more favorable in that jurisdiction. Obviously, Melania thinks she's got a friendlier platform if the case gets transferred to the Southern District of Florida. Now, if it does get transferred to the Southern District of Florida, it's not going to be Judge Viscasil assigning it to some specific judge she knows down there. It's going to go on to what they call the random wheel, the automated system that randomly assigns cases to judges. There are 3 judges in West Palm Beach, near Palm Beach, where Melania allegedly lives, and there's 1 judge in Fort Pierce named Judge Aileen Cannon. So if they try to get this case lodged in the West Palm Beach Division, it could end up with Judge Kenneth Mara, Judge Rodolfo Ruiz, or it could end up with Judge Cannon. And since one of those judges is on senior status and takes fewer cases, it's basically a 50-50 shot that it ends up with Cannon. And obviously, that's what they're hoping for. So that's where things stand right now. This is definitely a case worth following because it involves questions about residency, jurisdiction, First Amendment rights, and the limits of defamation law. Make sure you're subscribed so you don't miss any updates on how this all plays out.